KansasIQ.com. Masterpiece.
4. General Use Regulations, Section 4259, Temporary Uses, Subsection D. Specific uses and regulations of the Salina zoning ordinance to allow a second category of mobile food vendor to be created that would allow to be set up and sell food from a cart or a trailer in one location for more than 14 days. Dean, staff report.
Thank you, Mr. Chairman, Commissioners. This is an application for a text amendment, which is, in other words, a request to amend a portion of the zoning ordinance as it relates to temporary uses and vendors. And what we mean by mobile vendors is a vendor who does not have a permanent building and operating at a permanent location. But it's a trend I think we've seen in recent years, an increased amount of activity. Some are local, many are transient, but these are vendors or merchandisers who want to set up on a corner, or they might be selling T-shirts, Elvis paintings, bonsai plants. It could be anything. But up until 1989, the zoning ordinance didn't address it or expressly authorize that, except, of course, you could have sidewalk sales or sell vehicles outdoors or agricultural implements, things like that. But aside from that, businesses that were involved in sales, that had to be conducted inside a permanent structure that conformed with the local building code. Of course, we've had that discussion about the corner of 9th and Cloud and the greenhouse there, but this deals more with truly mobile or temporary vendors. And so in 1989, working with the Planning Commission, a whole new section was added to the zoning ordinance that deals with transient retail uses. And what was set up is that there is an application that you file. It's done administratively through the zoning administrator to obtain a temporary use permit. And there are lists that we have in the ordinance of permitted temporary uses. Some have very specific requirements, and there are time limitations for various types of temporary uses. And the applicants are required to clean up or restore the site to its pre-use condition when it's gone. And there's a mechanism that's been very seldom or almost never used, which is if the zoning administrator denies a temporary use permit, that can be appealed to the Board of Zoning Appeals. So especially in the summer months, it is pretty common to for weekends or weekly to have a request to set up in a parking lot or a particular location to have mobile outdoor sales. And the process is we try to review the sites to make sure that where they're set up is safe and accessible, there's parking for customers, that they don't set up in a place that obstructs visibility at an intersection or in the public right-of-way. From the state's perspective, they kind of like to see a retail state sales tax collected by any vendor, but that is not part of the local permit process. But again, the reason for the temporary nature of it is so that there's a level playing field with merchants who operate out of permanent buildings that meet local building codes and pay real estate taxes. Mobile vendors don't do any of those things. So what you'll usually see is a 3-day weekend or a 2-day weekend, and there might be a tent set up and a tool sale or things of that nature. And we currently have a provision that deals with mobile food vendors. They can set up at one site for up to 14 days within a 6-month period. So maybe Dillon's will have a promotional event and they'll have somebody who has a portable barbecue cooker, and they might come in for a weekend or something and offer hot dogs or barbecue sandwiches at Dillon's or Walmart on a weekend and then move on. But in this particular case, the applicants for this text amendment have purchased a commercial hot dog cart and have an arrangement with Lowe's Home Improvement Store to set up and sell hot dogs outdoors from their cart 365 days a year, weather permitting, and indefinitely. And so this conflicts with the current ordinance, which allows people to set up and sell at one location for a maximum of 14 days. So what we did in this particular case was we issued a temporary use permit for this for up to 14 days, and then that permit is extended until there is a decision made about this text amendment. So we've had different things that can be temporary, but temporary means that there's agreed upon date when a use or activity ceases. So if the Walmart store out at South 9th Street, they have a number of construction trailers, storage trailers, cargo containers there because they are actively remodeling that entire store, and they're storing merchandise and tools and things in those containers on a temporary basis. When their remodeling project's done, all those containers will be removed from the site because there won't be a need for them. So that's an idea of a temporary nature. Here, the arrangement with Lowe's is basically open-ended or indefinite, could last for 5 years on a continuing basis. So what's being proposed here doesn't meet the criteria we have in the ordinance. And so I think one thing that we do see here with this setup is that the applicants are setting up adjacent to and accessory to an existing retail store that can offer services both to the vendor and customers. And their argument is that should be treated differently than somebody who might set up on a corner or vacant lot that has no support facilities or services. So based on that distinction, we have drafted a proposed amendment that is you have in front of you, and I don't know, I don't think John has that graphically there that I can see, no, but it is in your packet, and it's titled Proposed Amendment. And what we were looking at here as a change to the ordinance is that if you are a mobile food vendor and you meet these criteria, then you can set up without a temporary use permit, without a defined end date or close down date. And that would require, first of all, that you set up on private property where there is an existing permanent business in a building with a CO, and Lowe's certainly meets that criteria. We would want to see a copy, which it could be a lease or something else, of written permission from the property owner to allow that mobile vendor to be there, and also to ensure that the vendor and the customers have access to a public restroom on site. That we would want to see a site plan so we'd know where the vendor was setting up exactly, and there should be a food service establishment permit from the health department issued before that location, and the particular, whether it's a cart or some other, a trailer or some other structure, and that we wouldn't want a temporary connection for water. I believe, as we understand it, that this has a self-contained internal tank to provide the water that they need, and they would get electricity from the store or have a self-sustaining generator that they would set up at least within 50 feet of the entrance to the building that has the certificate of occupancy, that they can only operate there during the business hours, that in this case Lowe's is open, that they have a valid and current sales tax certificate from the state of Kansas, and that they wouldn't set up in any parking spaces or driveways or fire lanes or public roads, and that they wouldn't have any sort of drive-through involved. And then what it wouldn't involve is that the, let's say the Schwann's truck or something that sets up in a parking lot, that would not be included by this. This would be somebody who has a cart or maybe a trailer that detaches from a vehicle or something of that nature. We would still have the provision for the person that sets up temporarily at Dillon's or Walmart for a weekend, but if this amendment were approved, it would set up a category that says if you can meet these criteria, then you would be allowed to set up under a lease or other written arrangement with a Lowe's or other retailer that had services on an indefinite basis. So that's our proposal, and we'd be happy to address any questions that you have. The applicants for the text amendment are here also if you have questions of them.
I have a question, though. Are they supposed to be carrying insurance, or is it covered by Lowe's in case something happens?
I think that's something that you would want to address to the applicants, or I'm not sure if Lowe's is represented here or not, but that would be covered by whatever lease or arrangement that they have with Lowe's.
Questions of Dean?
Dusty. Shipping. Dean, is there any stipulation as to that this has to stay up overnight, or can it be taken down nightly? Is there any thoughts on that?
I think if we were talking about a place that left or were taken down nightly, then it truly would be temporary. But if this is going to be allowed, the whole point is it's going to be there and stay there, and there wouldn't be any reason to have it taken down.
Under the current statutes, a vendor can stay there for up to 2 weeks.
Right.
Let's use your example of Dillon's and the barbecue place. So in essence, could they hire or have 26 different vendors stay there 2 weeks and have year-round service?
I imagine so if they wanted to.
If in fact that was possible.
Right.
Yeah.
They could probably do that today because this deals with one vendor setting up at any one location at any given time. And again, it has a lot to do with the level playing field approach. And now I'll give you an example. I have a trailer or something that I want to sell snow cones out of, and there's a vacant lot on a street somewhere. Should I be able to set that up year-round and sell snow cones from that trailer when somebody else on South Ohio has a full building and parking lot and all of that investment? It goes back again, one, to the level playing field, and two, if I set up my snow cone trailer on a vacant lot and I'm there all day, what about restrooms? What about support services like electricity or generators or things of that nature? So it's both level playing field and just safety and convenience of both the vendors and the customers. So under this scenario, if this were approved, the only place that this could be done is at a store or someplace that had those services available, not at a vacant lot where no services were available.
I have a question of Dean as well. Is there any precedence for this? I mean, I'm not familiar with communities, other ordinances in other communities such as Topeka, Lawrence, Olathe. Did you do any research on that? Is this kind of similar to what they may allow in those communities?
Well, and if the manager for Lowe's is here, they can speak to that. But apparently, this is a widespread phenomenon at Lowe's locations around, and particularly in Colorado, and we did make some inquiries there, and the approach. Specifically, we talked to folks in Greeley, Colorado, Lowe's there, and that they take a similar approach to this, treating it as an accessory use if there's a store, as opposed to setting up on a vacant lot where there's nothing that you're accessory to.
Thank you.
This proposed amendment we have here, Section 42-59D8, is for food only, right?
It is for food vendors only.
Now, the last sentence says, "Mobile food vendors who operate for 14 days or less shall be considered temporary food establishments." What's the significance of that statement?
Well, the significance for us is, one, we don't have a definition of our ordinance of what a mobile food vendor is, but a temporary food establishment, both for us and for the health department, would be somebody who does set up their barbecue trailer at Dillon's for 3 days, and they would be in that category, or somebody who's set up on a vacant lot or a parking lot without services.
And they come under a different ordinance.
They would be a temporary food establishment that could not set up anywhere for more than 14 days before they'd have to move on.
And they'd be covered under a different ordinance,
They would be covered under the current ordinance.
current ordinance, okay.
Current ordinance limits all food vendors to 14 days in a particular location. If this were approved, you'd have two categories. One, vendors that are accessory to an existing retail store like Lowe's, and those that might just set up in a parking lot or vacant lot somewhere that would be limited to 14 days.
Any other questions of staff? Now, this is a public hearing, right, Dean, in a sense?
If we didn't have, it is a publicly advertised hearing. We didn't do individualized notice, but the applicants and I believe the manager for Lowe's were notified.
Okay, before we hear from the public, we'd like to hear from the applicant. Would you like to approach the podium and give us your name and address and how you're involved in this thing?
Okay, well, my name is Barb Arnold. I live in Lindsborg, as does Dave Johnson, the other owner. And I wanted to say quickly in response to Ms. Benella Baker, we do have $2 million worth of insurance, and that's total liability. So we're covered in that area. I'll try to be as brief as I can. The history, about 6 months ago, Dave and I, who are both from New Jersey, but live in Lindsborg now, decided to open a very nice hot dog cart. Dave was working for Mark Scruton, the manager, and in this case, representative of the local retail, store that we've been discussing. Mark gave us a positive response that he thought it was a great idea to have a hot dog cart, a good one, outside of the store. We spent about 6 months doing research, and we also have an investment, to let you know, in Dave's Dogs of about $15,000. The cart itself was about $8,500, and it does have 4 sinks, its own water, it has its own power, everything. When we need it, Lowe's lets us use electricity. But we applied for a loan from SCED, and we did some looking into wholesale food companies, licensing. We researched foot traffic at this local retail store and spoke to several other food cart owners who had their business in front of other Lowe's in different states. Dave and I at Dave's Dogs consider ourselves an accessory to the primary use of this retail concern. Part of our process to get to where we are is an application and authorization from Street Eats. They are the go-between between people like us and the Lowe's. We pay a lease, and we have a commitment to this business and to the city of Salina. Some of the benefits of having Dave's Dogs hot dog cart in our location are we serve not only the employees of this retail store, but also their customers and the community. We've had people call up Lowe's to see if the hot dog cart was open today. And we offer a quality meal for a reasonable price, especially in these days. You know, we all have to kind of tighten up, and, well, some of us. We offer cheesesteaks, sirloin burgers and cheeseburgers, Black Angus hot dogs, Johnsonville brats, and some specials like a Reuben hot dog. Soon we'll be introducing a New Jersey regional hot dog, which we hope you will all try. It's called a Jimmy Buffs, or an Italian hot dog, which is a hot dog with peppers, onions, and potatoes on it. Just to bring a little bit of extra flavor into our setup. We do have our food handler's permit and our State of Kansas Department of Agriculture approval stamp. Under the proposed amendment, we do meet all the criteria to stay open year-round, and we really appreciate all of Dean's work, everything he's done to do research on this. In closing, because we have met the criteria of the proposed amendment and have a substantial investment in Dave's dogs, we feel very hopeful and positive that the Planning Board will adopt the new amendment and allow us to stay in business serving Salina. Do you have any questions?
Okay, any questions of Barb?
What are your hours?
Our hours are generally, we get there around 10 or so, set up, and whenever we have things cooked, we're open. We normally close around 4, but on Fridays and Saturdays, we close around 7 o'clock. If we deem it necessary, we stay later on the 4 o'clock days. It's just fun to do, to be honest with you.
The hot dogs sure look happy.
Yeah,
They're
that's
dancing.
me over there with the...
No, I mean, the little hot dogs on the side are dancing.
Yeah, we went down to...
They look happy? There you go.
That was in the facility in Orlando, Florida. We had the joy of going down there, driving with Dave's truck, of course, and picking up the cart ourselves. We had it specially made for us. And it meets all, I mean, it keeps food hot, it keeps food cold.
What do you do with a cart at night after you're closed?
Well, at night we load everything up that we can, that we need to, onto Dave's truck. Then we have a special custom cover that goes over it that keeps it neat, clean looking, and it's blue. And you can drive by well, you can drive by now if you wanted, but it's covered nicely, and Mark is okay with us keeping it there. It's quite a bit to haul, and it's chained down there, so.
Barb,
Yes.
what are your plans for winter?
Well, unless it's like really cold, we'll be there. We'll be there as long as we can. Of course, if it's really snowing, which doesn't happen much like last year, I mean, we won't be there. There's some weather conditions we can't be out there. Heavy storms, of course, it's common sense.
Plan on being there 12 months.
Yes, we do. If there is a dust wind coming in, we cannot be open.
Kansas?
I know. I know.
Kansas might have a deeper definition of what dust wind is.
I've been here 15 years. I know from dust, believe me.
I think you would have stood a better chance of an affirmative vote if you'd brought us samples.
That's what I was thinking too.
That could be considered a bribe. And we are doing this.
We're not beyond that. We're not beyond that.
Well, we've gotten very positive response from all the customers. We had many people come up to us today and say, "We saw the newspaper. We wish you good luck," and they were very positive. They don't want us to go. That's our impression.
How long
No-
have you been open?
About 3 weeks, Mr. Funk.
Longer than the
About 14 days.
Yeah, about 14. No, I'm not gonna. No, we're all on the up and up here. So, but yeah, I would encourage you to stop by.
We could do, I'm not sure about the drive-through. I kind of like the idea of throwing a...
Chucking as you drive by, I do too.
We could just throw like a, we've had people pull up and park illegally, which we don't suggest people
Right.
do, and run out and grab some. So it seems to be fun for everyone. It's something different for Salina, and
It didn't cost the taxpayers $30 million. What do you know?
exactly, and we also pay
You think this is
sales
going to
tax.
catch on? We're going to see this at lots of other merchandisers?
You know, that's a good question. I really don't know. I'd love to buy another cart and put it somewhere else and have Dave operate one and myself operate another.
Dogs.
Or maybe there's someone here we can hire part-time to.
There you go.
Okay, any further questions of Ms. Johnson?
Exactly.
Well, thank you.
You're very welcome.
Alliteration.
Now, this is a public hearing, so we're willing to hear from the public. If there's anyone here to speak for or against, or just have some comments regarding this ordinance, we'll hear from you. Seeing,
Question for you, Dean, though. If another vendor would like to go to another place, do they have to come back here and petition here again?
Go to a different place?
I mean, if
No,
someone off the street say, hey, that's a good idea, let's go to a Walgreens.
If this were approved, as long as you met these requirements, you could set up at Walmart or Dillon's, or this is not location specific. This is citywide, that's saying that instead of having a time limit on it, if you are accessory to another permanent business that operates in a building that has a certificate of occupancy and all the needed services, that you could do this
Exactly.
as an accessory to that use.
It's all handled administratively, right?
It's all handled
you
administratively.
come to City Hall for a
Right.
permit.
What the applicants are doing are plowing the road for people in the future. So if this gets approved, it would apply citywide if you met these criteria.
Now, they need
And
to
it
come
wouldn't
to
just
City
be
Hall
hot
for a
dogs.
permit. Do they have to renew that permit every year?
The only part that we would be looking for renewal is just to get confirmation from Lowe's or whoever the owner is that they have continued permission to be there.
Okay.
And that's something, when somebody, we've had situations before where bonsai plant salesperson sets up on a corner, the owner of the corner has no idea that they're there. And the policeman comes by and asks, see if they have their temporary use permit to be there. Well, in order to get one, you have to have written permission from the owner to be there. So if the policeman finds that they don't have that permit, then they move them off. So
They go to the next corner.
part of that
I
is...
bought 2 bonsai trees.
part of that's related to trespassing. So, I mean, owners do generally like to know if somebody's set up on their property and selling something.
Do
So,
you have an idea of the cost of the permit?
for this permit,
Yes, if the passes.
if this is done as an accessory use, people would bring in their plan, and we would look at their site plan. If it met this criteria, it would not be any permit at all, except from the health department. Accessory use means that it doesn't require a separate permit.
It's accessory to the Lowe's.
Accessory to the Lowe's, and as long as Lowe's gives you permission to be there, or Sam's Club, or whoever else, you can be there, if you meet these criteria.
Mr. Chairman, I move approval for application Z09-6.
Second.
We have a motion and a second. Any further discussion? Questions? All those in favor say aye.
Aye.
Opposed? Passes 9-0.
This is a...
Looking forward to your New Jersey hot dog.
This is a recommendation to amend the ordinance, so this recommendation will go on to the City Commission to be put into formal ordinance.
Keep your fingers crossed for them.
So we'll keep you informed on those dates of
When
when
will
the
it
City
go?
Commission.
I was going to say, when will it go to the City Commission?
Probably going to be the first part of August, but we'll let them know. We don't want them to have to shut down their stand to come down here for too many meetings. So.
Yeah.
Okay, thank you.
Thank you.
Okay, great.
We appreciate it. And on by.
Got a pen?
Item number 3, request by Ben Frick to modify the original conditions and limitations imposed by the Planning Commission as part of the conditional use permit number CU 04-7 approved for Dock Holidays, a downtown drinking establishment located in the C4 Central Business District. The subject property is the Phoenix Complex located at the northeast corner of 5th Street and Iron Avenue and is addressed as 100 North 5th Street. Staff report, please, Dean.
Thank you, Mr. Chairman. If you'll reflect back to your May 19th meeting, at that meeting you considered a formal request that was submitted by Ken Wasserman, a local attorney, on behalf of Big Nose Kate's located on North Santa Fe, and Big Nose Kate's had an outdoor balcony, and as part of the original conditional use permit approved for that establishment in the balcony, it was required to shut down at 12 o'clock midnight, and the request you considered at that meeting was an extension of that time to eliminate that restriction, and that would allow bar patrons to use the outdoor patio until the 2 a.m. closing time. This request is similar to that request in some respects, and in some respects not. But in 2004, Planning Commission conducted a hearing on an application filed by Ohio and Pacific LLC, and the plan at that time was to relocate a drinking establishment from the corner of Ohio and Pacific to the Phoenix complex at the northeast corner of 5th and Iron, and that in essence created a new downtown drinking establishment. The proposal was to establish a bar, Doc Holidays, on the first floor, and then there was a second floor as well that had basically a large banquet room, and the entire 7,200 square foot banquet building was the licensed premises. And after reviewing that floor plan, which is in your packets today, Planning Commission voted 4-3 to approve the conditional use permit, subject to the following conditions. You'll see 6 of them there, and item 3 there related to closing time of the upstairs balcony, which refers to the concrete balcony elevated on the Iron Avenue side. That was required to have no activity or close down at 12 o'clock a.m. And so we received the written request that you have in your packets following your action on Big Nose Kate's request. And so this was scheduled as a public hearing item for this date and time. And again, the items 3, 4, and 5 were related to address concerns about spillover noise, safety of pedestrians on sidewalks below, and also just for consistent treatment with Big Nose Kate's. And so, again, with the implementation of the clean air ordinance, the lifting of the restrictions on Big Nose Kate's balcony, Mr. Frick, the owner of this building, contacted city staff about expanding the hours of operation here. And for the same reasons that the original restrictions were placed by the Planning Commission, any change would have to be considered by the Planning Commission. What we have learned since that request was received is that the licensed drinking establishment, in other words, Doc Holidays, at this location is not currently operating and does not currently possess a drinking establishment license through the state that expired in 2007 and was not renewed. However, in talking with the applicant about whether then the request was to withdraw this request, or the answer was that there is still a possibility at this location for somebody with a caterer's license. If you had an event here or a wedding reception or some other type of event, a caterer who possessed a caterer's license could basically host that event, serve alcohol here. The balconies would be available for use, and so the 12 a.m. deadline would come into play there. Or it is also possible for a private party or individual to rent the space or the upstairs banquet room and use it for a private reception where alcohol might be served. And again, the concern by the owner was that the 12 o'clock limitation might apply in that circumstance as well. So the application that you reviewed in 2004 and the limitations that were in place are limitations on the operation of a drinking establishment in this location. So it's, on the one hand, you can't really have limitations on the operation of a establishment that doesn't exist, but the building exists, the use could still be present involving the use of the balcony. So the applicant indicated that the request still stands, so there's no uncertainty about limitations on the use of that balcony. The other thing I would point out is that when you review and approve conditional use permits, those essentially aren't for individuals, they're for locations, and you're saying that you've reviewed the location and the particular plan, and that the location is suitable for the operation of a drinking establishment. So it wouldn't necessarily be impossible for someone either to step into Mr. Frick's shoes or for him to try to decide to reactivate that license for this location. So from your perspective, it's a question of timing. Is this request relevant at this time, or should it be put off to another time when there's actually a operating drinking establishment? The applicant indicated that they wanted this hearing and this request to be considered because, again, it is possible for other situations on this property involving the sale, and not the sale, but the serving of alcohol or the use of the balcony to be in play. So this request was a public hearing item. Property owners were notified in the surrounding area of the nature of this request and the scheduled hearing date. So with that, I'll be happy to address any questions about this particular request or conditional use permits in general.
Okay, any questions of staff?
Dean, how do we, as a planning department, deal with a conditional use permit that has expired, say, for 2 years due to inactivity at that area? How have we dealt with those in the past? Do we have any other examples of something like that that has happened?
I can speak to one that wasn't a conditional use permit, and that would be the ice bar on North Santa Fe, where that was used as tailgaters, then it was vacant. Then it was La Casitas, then it was vacant. Then it was, now it's the ice bar after that period of vacancy. The vacancy of that space didn't take away the right for somebody else to go in there and operate a drinking establishment. You could have a situation where you approved a daycare somewhere and owner A operated the daycare there, owner B decided to let it drop and not operate a daycare there, then another owner comes in and they decide they want to operate a daycare there. Again, absent time limitations in the conditional use permit or us going back and saying we're going to treat conditional uses like non-conforming uses and make them go away over time. We've had a case when the 6th Street Pub was approved as a conditional use for a drinking establishment. It was approved for 6 months. And then the Planning Commission came back and reviewed how things were going after 6 months. That was a option, but that was the only one in the downtown area where that was done, and Big Nose Kate's and the others, like the 111 Lounge, there were no time limits on it, and there were nothing that said. I mean, I'll give you an example. There's a conditional use permit was issued for Martinis that's below Big Nose Kate's. The way our ordinance is presently structured, if somebody wanted to reopen a restaurant in there and serve alcohol, they would not have to come back to you to get a conditional use permit unless they completely changed the whole floor plan or concept. As long as what they were doing was consistent, they could move in there because you'd already decided that that was a suitable location for a place that served alcohol.
So unless there's a specific time limit in the motion on the original conditional use permit, it's considered that that use is acceptable.
Right, or a dramatic change in the plan. If somebody wanted to take Martinis and turn it into a dance club with a large dance floor, that would come back in front of you, because that's a change from the concept that you approved. But if somebody wanted to come in there and do another steakhouse that served alcohol, they wouldn't be coming back to you, because that conditional use permit was approved for that property in that location. Now that can be changed. You can do that one of two ways. One, by having a time limit in the approval itself, or going back and saying, if you wanted to say as a matter of policy that any conditional use permit that's issued for any property, if that is vacant for 12 months or 24 months or whatever, that permit's no good anymore, that can be done, but it's also very difficult to track when something goes vacant. I mean, this has not been the most active location, but until today, I had no idea that there was not a current drinking establishment license at this location.
Thank you.
Any other questions?
Well, as far as public safety is concerned, it's different for me if it's an ongoing drinking establishment than if once a year a caterer with an alcohol permit comes in, and then maybe once every other year somebody rents the facility and has alcohol. I think when you're managing a drinking establishment, it's very different from just every once in a while somebody comes in and consumes alcohol. But you're saying that that is permitted because this was a conditional use for a drinking establishment.
So it's not completely uncommon for, at the Salina Bicentennial Center, the way that alcohol was served there for 30 years was that a caterer who possessed a license came in and catered events there that served alcohol. And that's the way the Stiefel Theater operated until they decided to be their own drinking establishment.
But that was
limited.
yes, but it wasn't unusual for that to occur at either of those locations. Right. So when the applicant comes up, I'd be interested to know how many times in the last 2 years that has occurred.
And it's a difficult thing to categorize what exactly that is, and I don't know how to describe it as a loophole in the alcohol laws, but a place like the Labor Building on South Ohio, there are private events and parties in there almost every weekend.
Right.
They are not a drinking establishment. They don't have their own license. If a caterer goes in there, then they supply it, or you can have your own private event as long as you're just serving invited guests.
There's not a balcony and there's not...
Right, that you don't have those things there, but it would be similar to that of somebody renting space and having a wedding reception or other event that might involve serving alcohol.
If that was the case, if it was a private event, would the restriction of that closing at midnight still
It'd be
apply?
very debatable whether it would or not, but the applicant would like that clarified by having that restriction removed from the property. The concern was that if this was still in place and there were private events there, that it would cloud the issue of whether people could be out there past 12 o'clock. And he would like that cloud removed.
Mr. Chairman, if I may, if this is approved, then the conditions of this permit will be essentially the same as the conditions of the Big Nose Kate's. Is that what I understood you to say?
That is basically the request. It's up to you to decide whether the circumstances are the same, but
Okay.
yes, the conditions here are very consistent with what was applied to Big Nose Kate's, just with the attempt to be consistent.
Thank you.
Any other questions of Dean? I'd like to hear from the applicant, if you would, please. Your name and address?
Ben Frick, 120 Overhill.
Okay.
And Dean pretty well covered everything. We basically just want to be treated the same as Big Nose Kate's, and anybody that uses our place can look at it the same way and know there's not a different set of rules at ours with the police or anybody else versus any place else in town.
Okay.
How many times since it's been closed in '07 have you either had a private caterer or a private party use the facility?
I don't keep track of that, but it's used quite often. By the way, there's a health license there. It's approved by the health department. There is 2 other people that are using the kitchen for their extended group. So in other words, there's activity there.
Any other
We just
questions?
don't have quite as many fights as they do at the other places across the street.
That's a good thing.
Any other questions of Mr. Frick? Okay, thank you, sir. This is a public hearing. Is there anyone with the public that would like to speak to this issue? Seeing none, I'll bring it back to the bench and see what we want to do with it.
Well, no, sorry, whoever's.
Go ahead.
I think it's only fair. I mean, I have no problem with him setting himself up for a potential future business. I understand that maybe having some limitations might hurt his ability to rent, and I think it's only fair. We knew that these were going to be coming before us with the smoking ordinances, that we were going to need to make some amendments to help these businesses. I have no problem with approving this. I'm not going to make a motion, yell, everybody to discuss it, but I'm just going to put my 2 cents. I think it's only fair if we do Big Nose Kate's to allow them to as well. So,
Okay.
I'll go ahead and make a motion that we extend the hours of the upstairs balcony to 2 a.m. to coincide with Big Nose Kate's.
second that.
I have a motion and a second. Any further discussion? All those in favor say aye.
Aye.
All opposed? Carried 9-0.
We will, essentially, we did a letter of approval when it was originally approved, and we'll just do a modified letter of approval indicating that condition 3 is no longer in place, but these other conditions would remain in place about the plastic and cups and things of that nature.
Okay, item number 4, application number P09-6/6A, filed by the U.S. School District number 305, requesting approval of a final plat of Central High School subdivision on a one-lot plat being filed to establish the boundaries of Central High School campus.
Mr. Chairman, I need to excuse myself from this side of the table because I'll be part of this
Okay.
presentation, if
You're
I may.
excused.
That's a vote against you.
It's about time we subdivide Central High School, Dean. Report.
South
I think I still own part of this land.
Well,
This is Central.
part of me does and doesn't apologize for the very brief staff report, but when we looked at this, it's a lot easier story to tell than to write. So we're going to try to explain it that way. But I'm sure you're all familiar with what's recognized as the Central High School campus, and it's bounded on the north by Crawford, on the south by McAdams, and then framed by Front Street and also by Roach Street. I believe what you probably didn't know was that these right here are also remaining streets that exist, and so portions of the high school are occupying street right-of-way that probably still belongs to the city of Salina. So we're going to try to clean this up for them. But what occurred is that these different parcels that you see in your packet there this was the existing conditions in place. We had multiple owners there, and seemingly all of them weren't willing to part with their property, so the property was condemned. And so there was a separate condemnation on each of those actions, and they were pieced together, and the school district obtained all of that. This area up here, and including down, this is almost more like an alley than a street, but these were platted in the 1920s and never really dealt with. And so when the school was built and other things, it was looked at, and if you look at the city's maps for it, it's just one big blank open space. And I started getting curious about, there was a whole bunch of utilities and things there, but seemingly no easements, and it looked rather odd. And then we started working with Ken on things like fences and things of that nature, especially on the south side, and we couldn't figure out where the property line was there. And we had a number of projects, and they hired surveyors. I think in one case, the most recent case, it was BWR, Booker Willis Ratliff, and we determined that they couldn't produce a survey of the property because the boundaries on the Crawford, Roach, and McAdams side couldn't be established. So what this plat does is it will establish right-of-way boundaries on all four sides. And I think to summarize is that we have agreed to have 40 feet of right-of-way on the north for Crawford, and I got to get my note drawings back out here. But what this will do is clearly establish what is city and what is not city. So we will have 40 feet for Crawford, and we will have 20 feet for Roach, and then we talked about having a variable right-of-way on McAdams, but I think we decided to make it an even 25 feet there, and there's 37 feet of right-of-way on front. So on a normal situation with a public street, you'd have 60 feet of right-of-way, 30 and 30. But what we tried to do is look at existing conditions, what we needed to maintain roadways, and to not create a situation where some improvement that's on the campus suddenly becomes part of city street right-of-way. So we agreed upon 40 feet for the south half of Crawford, 20 feet for the west half of Roach, 25 feet for the north half of McAdams, and 37 feet for Front Street. And then the other thing we did was we looked at the situation of both public water and sewer lines, and that, in other words, city provided services, the franchise utilities, and then storm sewers. And so what was agreed to, and Dan's going to help me out here and reinforce, but there is got a storm sewer here that's coming off, draining that, and then there's a point. Is it on the other side of the drive or just a little bit farther west from there, Dan, that's going to pick up?
A little west of the drive, that's right.
Okay, so the only true publicly dedicated easement to the city of Salina is going to be right here, running parallel to McAdams, where there's a fairly large storm sewer. So that is going to be placed in a drainage easement, meaning that line will be owned by and maintained by the city. All of the utility lines, internal, in other words, water and sewer lines that are located on the property, including fire hydrants, those would all be continue to be private, to be owned and maintained by the school district. And so we wouldn't have internal easements in there. There's pros and cons to that. The con is that the city wouldn't be responsible or involved in the maintenance. The pro of that to the school district is, since they're their utilities, if they're in the way for something, there won't be easements or anything that might impede a future project. So if they decide they want to abandon a sewer line and build over it and put a new one somewhere else to accommodate an addition or a modular building, they can do that without having to work and get approval through the city. As far as the franchise utilities, I think Westar and Kansas Gas have identified their requests. John, if we could go to the north part of the preliminary plat, and I think we'd ask, Ken maybe can explain this project a little better, but there's a higher voltage transmission line that comes in off of Roach here that I believe serves the stadium, the scoreboard, some other things there. I believe the plan is to bury that, and Westar has indicated that that would also be a candidate for having a utility easement for that, because there could very well be a new underground transformer box placed in there. But both Booker Willis Ratliff, on behalf of the school district, met with all the utility providers, and we got comments from them as well, and we're pretty confident now. We now have lines identified that will be in protected easements, and also we have a number of lines there that are going to be private, continue to be owned and maintained by them, and will not be in easements that will encumber the property. But the other advantage of this is you are acting on the final plat, which is in your packet, which is actually the very clean version of the drawing, which only has a few easements on it and the perimeter boundaries established. And the benefit to staff and to the school district as well is the preliminary plat that was prepared by Booker, Willis, and Ratliff is going to be a very valuable drawing for the school district and others as they plan future activities, because it's the first time anybody's really had a drawing of the entire campus that showed all of the utility lines and buried things there so that everybody knows where everything is. So this is quite an accomplishment and quite a task for both the school district and BWR to take on, because this was a challenge to go back and recreate something that occurred in the late 1940s and has not actually been mapped until today. So with that, I'd be able to address any questions about the city's approach to the plat, and then I believe we have representatives of BWR and the school district here if you have more technical questions.
Any question of staff? Well, let's hear from the applicant. Could you please introduce yourself?
Ken Kennedy, 1204 Martin Avenue, Salina, Kansas. And I'm here representing USD 305.
Bring us a hot dog.
Hey, I don't have any hot dogs, but we could set up a concession stand there for football. I'm here representing USD 305, and I want to start by saying this has been an interesting project. My appreciation to the City of Salina for their assistance. Not only did Dean's office provide a great deal of assistance, but the city surveyor did some surveying that needed to be done well beyond our 40-acre plot, because some of the survey markers no longer existed, which saved us considerable time in the survey. The city's been helping us throughout this project. We did find some interesting things in this project. One is when we found there was a street going into the library, we took the meaning of a drive-in library to a whole new concept. And we haven't found anybody that wants the school back yet, thank goodness.
I'll take it.
But however, when we did find out that much of this property was taken by right of eminent domain. The problem with the court proceedings in that type of procedure is they don't necessarily get filed with the Register of Deeds. So the Register of Deeds office has no record, basically, of a large part of this property as to what happened to it. So you have to go back and dig through the court proceedings to see what really happened and when we acquired. And I didn't really realize that until we started in this project. So it's important during eminent domain that those projects continue on and get those properly filed with the Register of Deeds, and you don't have that void of knowing where the property is. And we thought for a while we didn't even own it. And when we first started looking at it, we said, there's parcels on here we apparently don't own, and we'd already built on them, like Salina Stadium, for example. So it proved rather interesting, and it was a good project to work through, but it's so much more beneficial to the school district than just even getting it cleaned up as far as registering it, is the fact that we never really had a clean plat showing where all of our utilities were. And we would struggle at times trying to find where our private utilities were as we were adding on and building. We would hit things and run into things, and we only had a history of the people that worked there to kind of remember where those were at. So now it will provide us a model to mark up and keep track of new services as we put them in. We do have some several pieces were put together by BWR as far as individual surveys that had been done over periods of time with the bond issue, with remodeling, with the addition we put on to the fitness area, with the tennis court additions, with Salina Stadium, the turf. There were various surveys that were done, but never were those put together in one survey for the entire 40-acre parcel. So we're delighted to have that back together. We're also pleased to be able to dedicate a wider easement for Crawford. The easement was never wide enough, and the city and the school district is doing that just for the benefit of our community and in appreciation for the city's help with us, but they're also giving us a little bit of option on McAdams so that we don't have to move some fences. So it's been a nice cooperative effort between both of us. Technical questions about easements and so forth, David Johnson with BWR is here, and he would be happy to answer those. I might mention, as far as the easement that Dean referred to with Westar, we have a high-voltage overhead line that goes from Road Street over to just north of Salina Stadium. It's our line. As much as we don't want it, Westar didn't really want it either. So we have to maintain a high-voltage line. So eventually, working with Westar, and we've started some of this, once this is approved, we'll continue that work in hopes of getting that high-voltage line buried so that we're not dealing with overhead cable, the things that we don't really have the capacity to handle. So we would answer any questions you have, and David would help us with any clarification of the
How long have you been working at this?
2 years? Jeez. Close? Maybe, initially started about 2 years ago, isn't that right, Dean?
Yeah, but I mean, David and his group have been struggling on most of the projects there. It was just almost impossible to put together a survey of the entire site, only in pieces that we were looking at, like the stadium turf, drainage, and things like that. So,
my initial involvement with this when I first came here, and we started talking about some additions, and I said, where's the property lines? And at that point, we didn't really know exactly where they were. And as you build out, and 40 acres it's important to know that 40 acres is never really enough for a high school, certainly a 5A high school. You would want more like 100 acres or 120 acres, so we're really tight there, and we have to build close to our property line. So that 4 years I've been a little bit working with it, but actively involved as far as trying to pull it together, about a little over.
Now, on your final plats, the last page of this report, you show easements. Those aren't public easements, those are private easements?
the easements that are there would be for Westar. I mean, they would be easements that are in locations where, are you referring to the south half or the north half?
Well, I'm referring to all the little easements all over the place.
David, you want to help us with those? Because David coordinated with the private utility companies on the locations of necessary easements. Some are public city easements, as Dean referred to, and then we have some others that are dedicated. So, if you would.
Again, David Johnson with Booker, Willis, and Ratliff.
Okay.
You're talking about the last page on...
Yeah, the last page, which says final plat. And it shows lots of little easements all kind of scattered throughout, on both pages.
Up up on the screen is the
Yeah.
last page of the plat.
Yeah,
The easement on the right-hand side that runs left to right. Thank you, Dean. I'll try not to hit you with the pointer. This right here is for an overhead power line, the high voltage line that Dean was that Ken was talking about for Westar.
okay, I guess I'm referring to that other bunch right there.
This here, this has a gas line in it that comes down from Crawford Street, as well as private water. And then it comes over here with gas and up into the courtyard and into the building right there. So we've got gas coming in here, and then we have power. This match line here, the second page extends on down here, so there's power that comes up from the south side.
Okay,
Yep, that's this one on this second page. So there's a power line that comes up here, ties over to the building, and then also continues north.
I guess where I was heading is, of the city engineer, does the city have any easements there for which they're responsible for the water and sewer, for example?
There is a note on the plat to be filed under survey notes number 5. If you can read that, it says, "All internal water lines, fire hydrants, and sanitary sewer lines within Block 1 of the Central High subdivision are private lines owned and maintained by USD 305.
Okay, good enough.
So that's clarified. And I might point out number 6, Dean mentioned the storm drain. It's a similar note. However, it says storm drain systems within this plat lying along Crawford Street and McAdams Street that serve the property and additional off-site areas are public lines owned and maintained by the city. Other internal storm drain lines that serve only this property are private and maintained by USD 305.
Okay, good, thank
So-
you. Any further questions of either,
I just hope this doesn't become a really boring TV show, like Planning Commission cold case files or something like that, you know?
Too late.
Give Dean a raise. Who found this? Did you find this?
Well,
that is the-
I
that is
asked
the-
Ken to prove to me that the school
That is
district
the
owned this
typical
property.
iceberg on geekdom right there. I'm telling you. Hey, wait a second here. I think I found something. McCoy, have a look at this. You know, it's like, it's amazing, isn't it, that this stuff can really go on this long?
And I think, it's just unusual that it can.
Yeah.
And I think it really didn't become an issue till we started building out more and more and found that we needed to acquire more areas and got closer to right-of-ways. But the interesting part is the work that the city had to do to really locate the survey stakes because they didn't exist on the section lines in some
John
places.
Harvey weeks to find those section corners. Weeks.
Really?
Weeks at a time, yes.
And
It's
so,
a long process to survey those all in and get them accurate. They haven't been there for 40 years, some of them.
I'll be dang.
which means not only is, our school, but it would have been difficult to have an accurate survey on many other parcels in that area.
In that area as well.
any further questions of Ken here?
I would like to make a motion to approve application number P09-6/6A.
I'll second that.
Any further comments or questions or comments? All those in favor say aye.
Aye.
Opposed? None? Passed. Congratulations, you have an up-to-date plat.
Exactly.
Where'd he go?
I did. That's right. Denied. You missed the votes.
Okay, item number 5, discussion of possible amendments to the city's sign regulations to allow churches and schools located in residential zoning districts to erect electronic message signs, board signs. This is discussion. Ken, why don't you come back to the bench? Thank you. We're done with your business.
Well, that's the school stuff.
Congratulations on a good job.
Good job, yes. Awesome.
Dean?
This is a continued discussion we've been discussing and over an irregular basis. This had come up before. There was not any, what I'd say, consensus from the commission. There was a comment that one of the things that we had asked earlier on in the discussion was, is there a reason to look at locations of churches and schools that are, say, that are zoned residential, but happen to be on a street like Ohio Street, to treat those differently than, say, one that was on a residential street. And the only comment we got at that time was from Mr. Appleby, who was on the commission at that time, who said, you have to draw the line somewhere, and he thought the line should be drawn on residential districts, and to keep the electronic message board sign out of anything that's zoned residential. Well, we do have things like the Salina YMCA, the large churches, Central High School campus that are zoned residential, and many of our churches and schools fall within that district. The other thing, it's not unique to Salina, but we have our sign regulations are based on district regulations and not use regulations. That is very common, but what it means is that a residence in a residential district and a church or school in a residential district have the same limitations, except they're a little broader for conditional uses. But just to give you a little bit of background, there was some discussion that even dates back to 2002, is whether our regulations are, when we have a 40-acre campus like Central High or St. Mary's Sacred Heart, and a facility is limited to one ground sign for that, is that too restrictive? One thing that we've run into, if you're on a residential street in your church or school, your sign has to be set back equal to the setback for a building, which is 25 feet. We've run into some issues with that at times. And then we had an issue that came up in 2002, and that dealt with the whole question of illumination. And we had a request from the school district to place an illuminated sign at Sunset School, and that was denied by staff because Sunset School is in a residential district and we didn't allow internally illuminated signs. Then we determined that, and we're not sure exactly how it got installed, but at the church just across the street from Sunset School, they had an internally illuminated ground sign. And so when that came to our attention, we contacted the church and said, well, the permit you had didn't say it had any electricity to it, so you've got a choice of disconnecting the electric power to the sign, or you could apply for a single variance for your particular property, or you could apply to the Planning Commission to amend the sign regulations, and they chose to file an application to amend the sign regulations. And so that amendment was acted on by the Planning Commission and approved, and so now churches and schools can have internally illuminated signs. The new issue here is that generally internally illuminated signs are static, in other words, non-changing messages, non-moving images, and the illumination is not real great, but we have been receiving inquiries. This might be the third one that we've had some inquiry on, but either from schools or from parent-teacher organizations representing schools about the concept of having the computer-operated electronic message signs at the school locations. Well, because they're located in residential areas, this form of signage is not currently permitted. But we think rather than trying to respond to these requests on an individual basis, that planning staff, and I think also this is where Mr. Kennedy and the administration's involved, is that the district needs to look at it as to what their position is. Is that something that they want to encourage on a district-wide basis for all elementary, middle, and high schools. And what their policy is as a district is it allowed if your parent-teacher organization raises funds for it, or is it something they want to move to on a uniform basis? But this was placed on your agenda to discuss the pros and cons of that. And before we worked with the school district or anybody else about filing a text amendment, we thought we would discuss the pros and cons and how you might craft limitations on that so you wouldn't have signs in schools and residential districts that became the same as the Speedy Cash sign or one of that nature. So, John, you had a drawing, I think, which is the concept. This is the concept that was discussed or presented to us on the Cottonwood Elementary sign. Basically, you've got the standard ground sign, static letters here, but the ability here, rather than to have hand letters that have to be physically changed, the ability to somebody in the school office to go out and send or retype a message and a command to make that changeable, more current, and less maintenance. And so there's different approaches to that, and certainly the way that our current ordinance deals with it is that they do treat churches and schools on arterial streets like Ohio different than local streets that might be in the heart of a neighborhood. But the other approach, rather than doing it by district, is to have regulations that apply to churches, schools, nursing homes, other institutional uses that happen to be in a residential district but aren't necessarily purely residential. So, again, the only guidance we received before in this discussion was that the line should be drawn between residential and commercial, but I have seen in the Wichita area, and there are other places where you do see churches and some schools with the electronic message board type sign. And I don't, did our spreadsheet make it in there, John? The matrix that shows where they're currently allowed? But you do, this is in your packet as well, but basically we've got a no right here, and so the only answer that we could give to individual schools or the school district or churches right now is no, that's not permitted. And there's some pros and cons to opening that up, but if you open it up, then it's also good to maybe have discussion about what the parameters of that might be. So this is on your agenda, and we're discussing, because we have information specifically about the proposed sign at Cottonwood, that's timely, but this would, if we take this approach, you're going to look at schools and churches across the board. And so with that, I'll open it up to any questions you have about the packet. I think there's two things that we could get some guidance on. One, does it make sense to you to have regulations based on the use, church, school, that type of that apply, rather than the general residential district sign regulations? And then the other part is if you allow electronic message boards in these settings, what parameters ought to be around that. And so it's helpful to have Mr. Kennedy, because he can tell us how the school district views that district-wide, and then it's helpful to have Mr. Mikesel, because he can tell us what his experiences have been. I mean, I think it's one thing if you have say a activity center that might have a football stadium or things like that, the type of signage you might want to allow for a central stadium might be different than at Cottonwood Elementary School. So getting some guidance on that would be helpful also.
Yeah, Ken, why don't you kind of summarize that for us, what
Well,
the school
first-
district is thinking?
First, I want to introduce Jerry Boxa, who is the principal at Cottonwood, and he can answer specific questions we may have about their intention at Cottonwood. A couple of preliminary comments before we go to specifically Cottonwood is the fact that we cannot and don't choose to advance this forward to our Board of Education. They're aware that we're making this presentation for discussion, but there's no way we would advance it to our board formally because we don't have authority to put in this type of sign. So it really needs to come to this commission first, and then if there's any type of endorsement, we'll then segue from there to see if Mr. Box's PTA wants to advance it, and if they do, then we'll take it to our board. So we're kind of taking it in steps. We also realize that we're here not to certainly answer questions. We're very interested in this, and we have various reasons for it, but we also want to be good neighbors. That's critically important to us. So whatever we decide here, we want to make sure that we are helping the neighborhood and not distracting from it. The particular signs that we have at our schools, and 6 of our 8 elementary schools now, I believe I'm correct on that, have some type of signage in front. The one problem we have with the type of signs that we use that are the changeable letters is the fact that it's very difficult and time-consuming to keep them caught up. And I imagine each of you have driven by and seen a school sign that says, have a good Christmas break, and you're not sure if we're talking about the last Christmas or the next Christmas.
Yeah,
in the middle of summer,
exactly.
And welcome back to school, and it's after school started. So we do have that difficulty, but I want to compliment our principals because I think they do a good job of keeping them up, but it's a challenge. Somebody has to be assigned to it. When most of these signs were put in, the electronic boards were not cost-effective or were not very prevalent. Now we're finding that that's much more easy to do, less expensive, and has the advantage of being able to just use a computer inside to keep your sign current. We also want to make a point before Jerry comes up and certainly can explain this much better than I, that I'm really strongly of the opinion we need to set time limits on these signs. Our purposes, and I believe that others, such as churches who are unique in residential districts, can live with a time limit on a sign that really shuts the flashes off or the lights off at a certain time, and we can do that with automatic timers, which we try to do that as much as possible where we can, putting in new signs so that we don't have signs on at 10 o'clock at night. So I would answer any questions.
My only concern is, with the budget cuts and everything, I mean, would it be financially, each district, each school be different? Would you set it up in our school budget to change these signs?
Yeah, the signs that we put in so far, they do have, as far as the signs that are in now, we don't know that they'll want to change them. They may. Most of the signs that have been put in front of the schools, and I would venture to say the majority, if not all, were sponsored by PTAs. They were a parent project as opposed to a district-funded project. However, we have invested some in-kind contribution, even to the extent of maybe we may help with some specialized wiring or something to get it outside the school. But by and large, the cost of these signs have been parent contributions, and I think that's similar to what they're going to want to do at Cottonwood.
We have 2.
Mr.
Boxer.
Think of a box, put an A on it.
Boxer, okay.
I'm Jerry Boxa. I live at 631 Briarcliff, but my wife these days thinks I live at 215 South Phillips, which is Cottonwood School. So thank you for having us today. And I want to thank all of you individually as well as from the standpoint of the city. You can't hardly believe it. It's been almost 10 years ago since the city, as a majority, decided to take a big leap of faith with the district and spend $99 million to renovate a bunch of schools. And I happen to be the principal at the only brand new elementary school built in Salina, Kansas since 1963. And that takes a real leap of faith for people to do that. I don't know what the finances were at that time, but there's never enough money to build and take care of schools. And the other thing about it is that school going into our neighborhood has really been a catalyst for that neighborhood. If you haven't driven down Phillips, Baker, Walnut Street and look at the area right around our school. There's many of those homes are beginning to have some rehabilitation, new siding, new roofs, trees being trimmed. And so by the district and the city working together to squeeze that school in a very tight location, again, Dean could probably tell you, that school is on a tight location. If they hadn't been able to work together, it wouldn't be there. So the area is very excited to have that school there, and we're excited to be there. It has been a source of pride for them, and occasionally it's been referred to as the lost school, and that's not why we're asking for a sign. But if you haven't been in that area, if I would just say Cottonwood School, people say it's over there somewhere. It's maybe by Gibson's, or, a lot of people talk about how to get to Cottonwood School by going down South Street and then turning on one of those other side streets. It's an interesting school. It's a great place. You need to come by and see it. So enough of that background. But the PTA has been working for about 4 years, as PTAs do, tucking away $2,000 from this bake sale and $500 from this bingo night and so forth. And they've managed to put away the funds to, and we're very proud of this, not to give the district a sign that they then have to tunnel under the blacktop to put the wiring in, but our intentions at some point are to give the district a sign turnkey. All they'll need to do is say thanks, and all the costs of it will be taken care of. So in doing that, though, we begin to say, let's make a sign that will last for 10 years, 15 years, not just the bricks and mortar, but also be one that will be one that is up to date all the time. I think one of the reasons that businesses put signs up is to communicate. We laugh about the one that was just mentioned earlier at the corner of Broadway and Crawford Street, but they're trying to communicate a message. In my business, it is imperative that I communicate with the 255 families that I have there. And not everybody gets communicated with in the typical way. Not everybody likes to read the newsletter to be communicated with. Not everybody listens to the same radio stations that I do to be communicated with. But most people in the course of a day or in the week walk their kids to school or drive by our school. And so our ability to communicate with them things such as enrollment is July the 28th from 8 a.m. to 7 p.m. To be able to do that is very important to me. It'd be very important to me on days that we have school closings because of bad weather, and I'm not unique in this. Elementary principals go to school every morning to be sure that parents don't inadvertently send their kids, or in some cases drop them off. I've had parents who've pulled up to the parking lot, let their youngster off, and drove away. If I would have had the sign where I could typed in "schools closed today," well, as a matter of fact, we have sandwich board signs that we put out on the street, and the principal puts his boots on and walk out there. So that's the kind of message that we're trying to put here. We're not trying to have, dancing, I'll borrow from we're not having dancing hot dogs across there, all those kinds of things. We're not looking for the phrase, I think, and I was learning things from you today, we're not looking at pulsating signs and things like that. We're looking at more of the message board thing that says, please use the Baker Street entrance today because of something like that. Like I said, I don't want to go on and on, but those are the kinds of things that we're looking for. We don't need to communicate with people after dark, primarily. We don't need to communicate with people much after that they go home from their daily work. So we're not at all adverse to, as a matter of fact, there will be a timer built on that because the district is going to be interested in saving some energy. Even if you're out from the middle of a cornfield, and if there isn't any traffic going by, we're going to be interested in saving the energy. So the timer's not an issue. I'll let you ask me questions if you want to.
How big is that electronic message board there in the middle of that?
Well, I'm not very good at reading a ruler or the
Scale.
Draftman's scale. It's about 12 inches by 3 feet.
Jerry, is
Would
it
it have-
color?
It is in color, yes.
Would it have one line or two lines?
It would depend on the font. I could put hello and make it be almost 12 inches high, or I could put hello at 2 inches and have several lines, which wouldn't be visible from very far. So the person programming it
That's all
has...
variable.
Right.
Yeah. I'll throw this in here, and I think we've talked a little bit about this before. The nature of electronic message centers is that they're getting away from lines of text, in other words, something being a set 6-inch height, and they're getting into pixelation, and the pixels are getting closer together, and that gives Jerry the opportunity to have his staff or students even, we encourage schools to use this as a learning tool for kids also, but they can program the thing, and they can play short video things. You can have a flag that waves in there. It's just a computer that controls an LED that goes on and off. And if this one goes on and off, it's like the wave we tried to do the other day in here. That's all that happens. So the concept of having an LED message center that is just 6-inch letters that go left to right is gone. And virtually these are ones that you can program to do about anything, which brings us to another situation. The old days of a time temperature sign are gone. Yours will have this ability, I'm sure, but the time temperature sign is basically just the same thing as an LED sign. It's just programmed to do a different thing. So in my mind, those are the same thing. But in terms of your request, they certainly can be programmed to go on and off at very specific times. Messages can be set to run. They can run a weekly message. They can run daily messages. The programming of this can be quite intricate, and there can be different messages on the weekends. You can have stuff you can leave for the summer and have messages come up every day during the summer, and different ones. But I think your correct request is for a very small sign by all rights, given the scale of your campus there, and also the scale of the monument sign around it. I think it's absolutely in character.
Password protected if it's Wi-Fi.
Don't laugh. That's it.
I know. I know.
Mr. Box, you fill in the blank now.
Yeah.
We don't know.
The latest thing is 128-bit encryption on signs, and I just learned about that because we put one up for a bank recently. So that is a.
And I tried to talk to the neighbors. We're very conscious of the neighbors and the fact that we're in a neighborhood currently, and that's unfortunately currently 2 of the residences directly across from the sign aren't occupied, but there is one that's probably at the corner of the street, and then one far. And we talk with them. One of the comments that one of the neighbors made that lives on the corner of Phillips and Walnut, and there is a pedestrian-activated crosslight there, and this isn't meant to be critical, it's just an observation, is that, and this year we didn't put them to yellow for a number of reasons, but it's just that I can't imagine that would be any worse than having the red flashing light. And, so we have a cross light doing this 24/7, not,
Oh, dear.
and so that was their reaction to the fact that we might put a sign similar to this in that neighborhood. Now, I can't speak I didn't poll everybody up and down that street, but that gives you some sense for it, at least.
We always advocate responsible programming, that you do want to get along with your neighbors, and if you've made somebody mad by a message that you've put on your sign, that's probably not going to be conducive to business or patrons or anything else. And obviously the benefits from these type of signs for a school or a church are massive, and can only increase goodwill and participation in your district.
Yeah, I would think by the time they get around to this sign, prices are just continually dropping. Everybody probably knows your 215 South Phillips, maybe go with a bigger screen. Let's get some big images on this thing, you know what I mean? That screen just looks too small for me. I just want to see something a little bit bigger. See, I support the LED.
You have to live within your means.
I support the LED signs. Well, I'm saying the costs are going down, so.
But the interesting thing on a sign like this, too, is that we have to buy 2 of them.
Yeah, it's a front, I thought it was facing out to the street. Oh, it's okay, it's
so
going this way.
So this is going to be a
Okay.
two-sided sign. And
I've got you.
From a cost of a PTA, they're wanting to take
Yeah, sure.
baby
About
steps.
what will a sign like that cost approximately?
Are you talking about the LED
No, I'm
itself
talking
or
about
the
whole
entire sign?
installation.
Installation, we're hoping to come in a little under $10,000. That means we pay to have it bored under the street, and, you know, because we have a parking lot, and so the line has to get bored under the parking lot, and then conduit to hook into electric, and conduit for Cat 5 cabling and so forth. And so
Are you going to have someone trained for maintenance in case something happens, or is it?
typically what
Warranty?
happens, we make a gift to the district. We attempt to, the district looks at it and says, can we afford to accept it? How much do we have to pay to put it in? That's why we want a turnkey right now, because I work for the district, and you all help pay our salaries. We don't have extra money. We don't have $3,000 extra to accept a gift like this. And they also say, what's the cost to operate it? How many kilowatts or whatever it is will that little sign use blinking so many hours a day? Plus,
Pretty cheap.
then...
Oh,
right.
extreme-
Oh,
that-
cheap,
Right,
yeah.
but to get to your question, the other thing is that the district also then looks at it and says, okay, what happens if that thing gets vandalized the day after tomorrow? You know, our PTA, the person that I'm kind of, the group I'm representing today, that would be a crushing blow to them. I would imagine they would try to go ahead and purchase another one, but the district often will then be faced with the dilemma, can we afford to replace it if in fact it's, but that's why we have that whole approval go with the Board of Education. We just need to know whether or not, we don't want to do anything to jeopardize a relationship that the district has with the city of Salina. The thing that just happened before with the plating, you know, the city and the school has to work like this, and we don't want to do anything to create any kind of wedge. So we're here just saying, think about it.
To answer your...
As we, and to follow up on that, almost invariably, when a donation is given to the school, it's real property, the Board of Education then takes possession of that. So the ongoing responsibility of maintenance, repair, insurance coverage becomes the responsibility of the district. Our board will look very carefully at this, and they'll have some of those same questions. What do we expect the ongoing cost to be? And they'll adjust that and say, can we do it or not? The other thing that I want to mention before it slips my mind is that you mentioned the size of the sign area. While I think this is very appropriate, this is what Cottonwood wishes to do, the city has a limitation on the size the sign may be, and I believe that's about 32 square feet. I would, whatever we do as a commission, I think we need to outline that size limitation, because I'm sure the next school that wants to put one of these may want to use the full 32 square feet, if that's going to be within the permission of the commission here. So I think we determine that now. While Cottonwood may choose the size they have, another may choose a little bigger, one may choose a little smaller, but we need to know what that limitation is.
So we have to approve this, or can you come in and apply, then they have to get approval from you in order for it? So it's basically a two-step process?
Right. As with the current signs, we come to the city and get approval to put our current signs out there before we start down the road of getting board approval. We want to make sure that, and if it's already listed in the regulations, Dean makes that administrative approval, and we step forward with it. We get a permit.
We can amend this and say, this is the square footage, this is the operation of hours, this is the, okay.
Today, this type of LED sign in a residential setting like this, the only answer we can give is no.
No, right.
If the commission is comfortable with changing that answer to yes, then your job working with us is to give us some parameters to say, well, we mean yes if the sign is no bigger than this, and if there's an agreement that illuminated signs will continue to be shut down at 10 p.m. or 9 p.m. or whatever you think is appropriate.
Well, we could start outlining that, like 6 to 10 for hours. Does
I was
that
just
seem
going to ask, do you
reasonable?
have an idea of what hours you would want?
Beyond what our needs are, and Jerry explained it very well, I think, in that our needs more are the working hours,
Right.
8 to 5. But what we do here, I hope we'll think about other
Right.
churches and
Sure.
so forth, and they may have different
Not
hours.
just schools.
It's
Right.
not just
That's why I
us.
said
We're
6
kinda-
to
We're kind
10.
of serving as the
Right, I mean, if we do I don't know, 6 to 10,
Yeah.
but maybe,
Well, that seems
Yeah,
reasonable. Some
I'm-
people are going to work at 6, and 10 is,
6
we have our noise ordinance kind of cuts off at 10, doesn't it?
10 p.m.
10 p.m., so it seems fitting for
that
lighting.
would seem reasonable.
Dean, are all residential districts 30-mile-an-hour maximum speed limit?
They would be, except if you're on Ohio, you've got a 40-mile-an-hour limit. So we do have, there's residential properties. I mean, South High and Central High are on, they're zoned residential, but they're on arterial streets like Crawford and Magnolia that do have higher speed limits than 30.
What I was getting at is commonly when we are figuring the size of a digital sign to perform a function for a reading audience, what we'll do is we'll figure the mile per hour and the distance away from the viewer. Those are things that I can give you a chart and you guys could figure that. I don't know right off the top of my head what that might be, but it'd be, 20 square feet or less.
It has to be a certain size in order to be readable, traveling at a certain speed.
And what'd you say, 32? Is that what you were kind of saying? You thought 32 was in C?
Well,
Was in
right. Today, any church or school, the maximum ground sign they can put up in total is 4 by 8 or 32 square feet. So in this particular case, they're talking about taking a 1 foot by 3 foot area of the 4 by 8 and making it available for electronic message. Your options range from having a cap like that size or slightly larger to saying if you can have a 4 by 8 sign, you can have a full 4 by 8 electronic
seemed reasonable to me. If we're going to
message,
shut off at
because
6 to 10.
we're measuring the sign, we're measuring this, even though the structure's big.
Sure.
That's
Sure.
limited to 4 by 8. If this is bigger than that, that doesn't count.
Right, anything that couldn't physically hold part of the message isn't really counted.
Right. So right now, it doesn't matter if you're a small school or a large school, you can have a 32 square foot ground identification sign.
And again, if we did that 4 by 8, I mean, I'm okay with that, but say Salina Stadium, decided they wanted a large one, they could come in for a variance from us at that point.
Right. Or we could try, when we're writing it, to make stadiums and athletic fields different than school sites.
Let me just say right off the bat, I appreciate your thoughts. A 4 by 8 digital sign has a tremendous amount of power. That if I was a neighbor and they were going to put up a 32 square foot LED sign, I would be disappointed. Because it can be very bright. And again, responsible programming is what we always advocate. I would like to see that number probably be in the 20 square foot range maximum. And you know,
Or electronic sign.
And for
Yes.
schools, that, for most, especially for our neighborhood schools, that's more reasonable, because during the day when parents, those are 20-mile-an-hour zones typically anyway, so you're even going slower. And our signs are, just about all of them are placed, except for a couple of exceptions, where parents drive through a circle drive and they'll stop and they'll be able to see the sign. So
Sure.
for communication purposes, something smaller. But I think that's important for us to look at here, because what we said here, then we won't have to deal with another conditional use permit every time somebody wants to.
Right, and that's why I say maybe go a little wider, because the churches may want a little something. You know how they are.
yeah.
They might.
Got that big religious message they got to get out there in living color.
And again, like your campus, it's a different feeling than say,
South High.
exactly.
That's right.
You know, the more area that's around the thing is going to definitely, in my mind, influence the size of the sign that you put up there. I would like to work with staff a little bit, if it's okay with the rest of the commission, to develop, or at least look at some recommended sizes for readable lettering and stuff, and then maybe bring a recommendation back to the board based on that. Does that sound reasonable, Dean?
Sounds good
Yes.
to me.
But what we would be looking at today is that, I think we pointed that out, it's just on your last page there, on this particular item, under current statutes and zoning regulations, there are 3 ways that you can initiate a change to the zoning ordinance. One is you can do what hot dog cart people did and say, we don't like this provision, we want to initiate a change, which they did. School district could initiate that, or based on what you've heard today, you could initiate the change, and you could do that today by making a motion to direct us to prepare a change that would allow for LED signage for churches and schools, and we could work with Patrick on some of the sizing and things like that and come back with a specific. But in order to come back with a specific proposal, your motion or action today would say, we're receptive to considering these types of signs for churches and schools, then you want to direct us to
So on that
amendment.
matrix then that we were looking at, we'd change the no for electronic message board in residential to yes.
But yes, with an asterisk, and the asterisk would be under these parameters.
Sure.
But we want to keep the signs with flashing, pulsating lights, animated display. We want to keep that a no in residential areas.
When you're talking about those, you're talking about like what Payday Loans has, what what the car dealers have down on Crawford.
They're all the
But
same
I'm going to
size,
tell
it's
you,
just
though,
programming.
his sign will have the ability to do the same thing.
Well, but we're not going to permit it to do that in a residential area, in a school district.
Okay? Here we get into definitions.
I know where you're coming from,
Yeah.
but I think we can define, we can come up, and maybe that's what you can work with Dean, we can come up with, even though we know the signs are capable, programming of that type won't be allowed,
Yeah.
you know.
We don't want to get into, Manhattan allows digital signs, but you can't change the message. I think you're only allowed to do that once every 24 hours. I don't think that we want to get into that. You know, you're going to have you've got a small information area, and you need to get that changed on a relatively fast basis to have people be able to read it. But also, you don't want anything that's, you know, sale next 24 hours. That's not going to be appropriate for you. So what we have to come up with as a commission is language that's suitable for that. I would say animated display would be something I'd have to scratch off of there, because you will get, I guarantee you, with your new sign, you will get a video package that will have some animations in there. They might be cute little things like kids chasing rabbits across the lawn for Easter. They'd be a waving flag and some stuff going pop for fire or for the 4th of July. But those are all packages that they sell with signs, and they are common.
I think the only analogy, and I'm not very technological in any of those things, is that I could buy a car and put some massive boom box bass, whatever's in the trunk, and have unlimited volume. You know, and you couldn't prevent me from having that in my car, but you could regulate when and where and how loud it could be done. And I think,
Right.
you know, the thing about it is, when you start doing computer graphics, you could do almost anything, but where you as a planning commission or the city commission at some point are going to say, of all of the things you can do, these are the only things that would be acceptable given this is a residential area. And I think, and I don't know if the radio thing is a good analogy, but, you know, the volume on the radio
think
goes
so.
a lot louder than is legal in some places.
Yeah.
There's really three things that I think would be appropriate for our use, and I think would apply, is the size that you feel comfortable, or this commission feels comfortable, the times of operation,
Right.
and then the type of graphics that can be displayed, the bursts and so forth. They're all capable of it, but if we can look at those three things and work out something with the city, then I think we could all agree to that.
I
Plus,
think
we would certainly welcome any response we have. We want our patrons to be satisfied with what we're doing as well.
I don't think we're going to have any trouble with the school district. I think the churches are going to want more animation.
I think so, too.
And I think if somebody has an insurance service or something down there, I think the churches are going to probably be our number one, saying, yeah, I want to be able to have something. I just think they're going to be wanting more animation in theirs than you guys would want in yours.
There's one other consideration now that you mentioned that, Dean would have to answer this question, but something we need to consider, in my opinion, is, well, I'm terribly supportive of this for churches and schools. How would that apply to businesses that are allowed in residential area?
Well, and throw one more thing in there. What about daycare?
That was my point. Daycare and hair salons and so forth, I think, are allowed in residential sometimes.
Yeah, they're very limited on the area of signage that they can have.
I would
It's
be
limited to signs that are hung on the wall, but that's why you
Somebody has
see
a
these
daycare,
references
that's
here.
20 square foot.
We're talking about churches,
Jumbotron.
schools, and things like Eagle Crest Retirement Community or places like that. And it's if you limit it to that,
I
then
think
you're
we
not
could
opening the door to the home beauty shop or.
I think starting off just limiting that's a real good idea. Narrow the scope for now.
One question, another question. I'll make this simple. Is there a dimmer switch, or these have one brightness and that's it?
Well, no, least the ones we
Yeah,
sell.
dimmer switch is kind of a,
Yeah, no, that's a good analogy. The ones that we sell now, there used to be just a dimmer switch, just like you said. There was a photo cell, and it said, okay, it's dark, I'm going to tone this down, and it would go down 30%, let's say. Well, now, the ones that we sell, they have a photo cell, and they go dim in 160 different levels. So it's, and the nice thing about that, I don't know if yours is going to be this way, let's say the sign that's on the west side of the sign, that will dim at a different rate than the one on the east side. The east side one gets darker quicker, so it goes down faster. The west side one goes down
what I'm
slower.
thinking about is at 10 o'clock at night, if this thing is super bright and somebody's trying to get to bed, or they're trying to get their kids to
Yeah.
bed, and this thing's,
Yeah, I think we need and absolutely should require mandatory dimming. If not, two things happen. The message becomes unreadable and offensive, and, if you're a neighbor and you're trying to sleep with something like that going on,
Right.
especially if it's a moving display, can be very annoying.
well, and I'm thinking about a lot of kids are going to be going to bed earlier than
Yeah, I think
10
that-
o'clock.
I
So
think,
I'm-
and we've talked about the dimming thing.
Yeah.
Yeah, I think dimming is more important than message. I mean, even if that Crawford and Broadway location was flashing, but it was dimmed down, it wouldn't be near as offensive. If it was dimmed down 50%, I'd be okay with it flashing.
Well,
But it's that
we're
bright.
getting into details
Yeah.
now, and I think what we need to do is, do we want to initiate a
Yeah.
Yes.
proposal here to study this whole sign issue, which Dean,
Well, it'd be we would prepare a proposed amendment for you to take apart.
right, and in that'll be a lot of details, and it'll take quite a while to work out. So I think what we need is a motion to put that into effect.
I would make that motion in whatever language you'd like that, to initiate a change to the residential section of digital signage.
And I'd second that, and again add that you're going to maybe meet with Dean and
Yes.
come up with something.
You're excused, we'll vote now.
That will allow us to
Thank you, Jerry.
initiate that, do drafts, schedule public hearings, make it an active item, just like the hot dog cart at the front of the meeting.
Okay, we're initiating a study here on possible sign ordinance revision. That's fine. All those in favor say aye.
Aye.
All those opposed? Carried 8-0. Next item is other business.
Other business, we have a somewhat similar request to have you authorize us to, our state sandpit industry was so kind as to squeeze through an amendment that was of statewide application because our state statutes that we have that govern zoning and planning cover every city and county in the state, and they were able to pass a statute that took away people's protest rights if you had a conditional use permit application for a sand pit. So, because that's of statewide application and because you can apply in agricultural zones for a conditional use permit to have a sand pit, we're forced to amend our regulations to adjust to the statute. But I think that statutory change was tied in with the sand pit proposal that the county is currently reviewing, but because our statutes apply uniformly to cities and counties, we have to go in and change ours to conform with law. So we would request your permission to initiate that change to the conditional use permit process,
Take a motion?
or just your assent that
Consensus?
Yeah.
you would be the sponsor. We have to do it to comply with state law, but we can look at some other things like what we discussed earlier about time limits on conditional uses or their expiration or things like that. But it's the section on basically what it says is that if you consider and the Rendezvous Bar would be the example, you have a conditional use permit for a drinking establishment, you take action on it, neighbors file a protest petition, that forces it to the city commission, and they can't approve it without 4 affirmative votes. What the state law change said is if that application's for a sand pit and not a drinking establishment, you can't do a protest petition. So it's what you
How-
call special interest legislation.
Then, but the county opted out of that, so how does that apply to us?
What the opening there is that on the county side, the statutes are uniform except for Johnson County has its own planning enabling legislation that's separate from the other 104 counties. Therefore, the county's legislation is not uniform to all counties because of Johnson County is not covered. So that allows, because it's not uniform to all counties, they can opt out. But
The city doesn't have
any
that.
statute that applies uniformly to every city, cities can't opt out of. So the county was able to opt out because Johnson County is not covered by that statute. That was their loophole. Yes, I'm the legislative liaison for the Kansas Planning Organization, and I learned about the law in the Salina Journal, so I'll give them credit for it. I'm supposed to know about those things, and I didn't know
You're not as geeky as I thought,
that
Dean.
they
Dang
did
it.
that
Dang it.
through. So,
So
well, that's good
what
to
if
know.
we did want to have, I know that's the state law, there's no way then the city can
The
have.
city can't have a process or a procedure that deviates from state law. So all of our things on protests and notifications and all those things are all governed by state law. Even the statute that says that only planning commissions, city commissions, or in other words, staff, as a staff member, I can't initiate a text amendment change to the zoning ordinance. I can come to you and try to persuade you that it's needed, and if you agree, you can sponsor it. But I can't just come to work someday and say, I think I'm going to initiate this change. So that is spelled out in state law. So a lot of what we do procedurally is governed by that, and along those lines, we were going to try to use your August 4th meeting for study session on that subject with Greg Bankston, our city attorney, and also talk about our new flood maps and what impacts that might have on community and different parts of the community. So we'd like to use that time on August 4th, which is your next scheduled meeting, for those items.
And not have any other business.
I don't think we'll have any other business.
Not an early meeting, just a regular time.
I think we'll use the 4 o'clock time, since we don't have any other business that we know of. And then we have a number of items scheduled for the 18th, which would be regular action, a pretty busy agenda there. So that's what we have upcoming that we'd like to work with you on, would be to update you on flood maps, and then just some of those procedural items, and get some of Mr. Bankston's time to ask questions and things that you might be curious about. So we'll be initiating those two things. For those, I don't think anybody else, his 3-year term is up for renewal, but July 31st is the deadline for expression of interest forms if you're at a point to be eligible to be reappointed. I think Mr. Schneider's 2 full terms are done at the end of August this year, so he's not eligible for reappointment. I think everybody else is in the middle of terms
Nope,
right
I'm done.
now. You're done?
I'm done.
You're done? Your terms?
My term. Well, just one term.
1 term. So
Where are you? Right.
I didn't have, on our list, I didn't have your 6 years. I had Mr. Schneider's, but not yours, so I'll
In fact, I think
check
mine's
that.
7 years.
Because you took over
If you took over for somebody's unfilled term, then you can do that plus 2 terms.
Well, I know it's 2 terms for sure. I'm just
Okay.
not sure that,
So what we'll try to do is get an email from Alyssa out to everybody as to what your status is. But if you're not eligible to be reappointed, then submitting an expression of interest form is not worthwhile. But we'll try to identify anybody who might want to be reappointed that they need to get that turned in. But July 31 is the date for that, and then the appointments are usually made in August sometime because terms end at the end of August and new members come on in September. So we'll try to get an email out that updates you on your status. See if that agrees with your recollection. But that's all we would have for you today, and we appreciate your time and attention.
okay.
I do have a
meeting
plaque
adjourned.
for Mr. Funk to sign.
Oh, you did?
Yeah, true.